Welcome to the Deep Dive. We're the place you come to when you need complex legal stuff broken down, really giving you the insights you need to be properly informed.
And today, we're definitely diving deep.
We are. We're tackling something pretty fundamental, the legal boundaries of family. Specifically, we're digging into Chapter 25 of the Penal Code. It's literally titled, Offenses Against the Family.
Yeah, and this chapter, it's really the framework, the legal architecture that says when violating those core family relationships becomes a crime. We're not talking civil court stuff here, like, who gets the furniture in a divorce.
Right.
This is about when things cross the line into potentially felony territory, violating court orders, betraying legal trust.
That's a really important distinction to make right up front. Okay, so let's unpack this then. Our source material today is, well, it's dense legal text, statutory language, very technical. But our job here is to decode it for you. We want to make clear what counts as a legal family relationship, marriage, blood ties, adoption, even protective orders, and figure out when breaking those rules becomes a serious criminal matter.
And this isn't just academic. If you're dealing with custody issues or domestic violence protection, or even just want to understand how the law views these foundational relationships, this stuff is, well, it's vital.
Absolutely. Now, before we jump into the very first statute, just a quick but really essential thing. We put a lot of work into taking these dense sources and making them, clear and useful for you.
We do.
And your support makes that possible. So if you find this helpful, if you want us to keep doing these deep dives, please just take a quick second right now and hit subscribe on the channel. It really helps us grow, helps us reach more people.
Yeah, it makes a big difference.
And also, don't forget, our website has the full transcript for this whole discussion, plus links to further reading if you want to go even deeper. Check that out.
Definitely worth a look.
Okay, let's get into it. Part 1. We're starting right at the foundation, really. The legal contract of marriage. Section 25.01 covers bigamy.
Right.
Now, I think for most people, bigamy just means, marrying two people at once, secretly.
Mm-hmm.
But the law here seems broader than that. It looks like it targets both the person doing the deceiving and someone who knowingly goes along with it.
That's exactly right. The way the statute's written, it's designed to catch the criminal behavior in a couple of different ways. It doesn't always require an actual legal wedding ceremony to have happened. The main goal is protecting that existing legal marriage.
Okay.
So the law basically focuses on two main people, or actors as the code calls them. The first one, under subsection A1, is what we could call the legally married actor. This is the person who's already married legally.
Okay.
They commit bigamy if they do one of two things. Either they purport to marry someone else or they actually do marry someone else. And critically, like you hinted, the law says it doesn't matter if that second marriage or attempted marriage happens out of state or even in another country.
So the law follows the person.
It follows the person. But here's the other way they commit the offense, and this is where it gets broader, like you said. It's also bigamy if that legally married person just lives with someone new under the appearance of being married.
Okay, under the appearance of being married. That sounds like it could be pretty strict. You don't even need the ceremony.
You don't. It is strict. The idea is to protect, the public's trust in marriage as an institution. Now, that phrase, appearance of being married, it's actually defined very specifically in subsection B.
Right.
It needs two things. First, cohabitation. That means living together, basically like husband and wife. And second, there has to be the intent by at least one of them to be married, plus they have to be holding out publicly, telling people, acting like they're married.
Got it. So just having a roommate isn't bigamy, obviously.
Right.
But if you're living with someone and you're telling the neighbors, this is my wife or this is my husband, even though you're still legally married to someone else,
yeah,
that's where the line is crossed.
Exactly. It stops someone who's already married from just, say, moving somewhere else, shacking up with a new partner, and pretending it's a whole new legitimate marriage.
Okay, that makes sense. So that's the first actor. What about the other side of it? The person who gets involved with someone they know is already married. Subsection A, the knowing participant.
Right. So if you're that second person and you know your partner is still legally married to someone else, you commit bigamy if you do the same things. You purport to marry them, you actually marry them, or you live with them under that same appearance of being married standard we just talked about.
So the law holds both people accountable for the fraud on the original marriage.
It does. It criminalizes knowingly participating and undermining that existing legal structure.
Okay. But, life gets complicated. What if someone genuinely thought their first marriage was over? Maybe they thought their spouse died, or they got divorced years ago and lost the paperwork. Is there any defense?
There is a defense laid out in subsection C, but the lawmakers made it pretty narrow. It's a defense if the person reasonably believed the prior marriage was void or had been legally dissolved, by death, divorce, or an annulment.
Okay, but reasonably believe, that sounds like the key phrase. What makes a belief reasonable according to the law here?
And this is where it gets incredibly strict. The statute is very clear that belief is only considered reasonable if you can back it up with official certified documents.
Oh.
We're talking a certified copy of a death certificate or a court document signed by a judge or clerk confirming the marriage ended like a final divorce decree or an annulment order, nothing less.
Wow. So let's say my spouse disappeared 20 years ago. I honestly believe they must be dead, but I never went through the process to get them declared legally dead. I don't have a death certificate.
Yeah.
If I remarry, I can still be charged with bigamy.
Under this statute, yes. It seems incredibly strict, but it deliberately closes the door on defenses like, well, I just assumed, or someone told me they were divorced.
You need the paper.
You need the paper. The legislature is demanding a high standard of proof, basically shutting down excuses based on hearsay or just wishful thinking.
Okay. Now, shifting gears slightly, there's a point about who can testify in these cases. Subsection D. It seems a bit unusual.
Yeah, it is interesting. It says that the lawful spouse, meaning the first legitimate spouse of the person charged, can actually testify for or against the person charged when it comes to proving that original lawful marriage existed.
So the original spouse has a potentially powerful role in the trial.
This certainly could, yeah.
All right, let's talk consequences. Penalties. These seem quite severe, and they get worse depending on the age of the second partner involved. What's the baseline penalty?
The standard baseline offense for bigamy is a felony of the third degree.
Okay.
But subsection E ramps it up significantly based on the age of the person the defendant marries or lives with under that appearance of marriage. If that second person is 17 years old, the offense jumps up to a felony of the second degree. And if that person is 16 years old or younger, it becomes a felony of the first degree.
First degree felony. That's serious.
Extremely serious. It shows a very clear legislative intent to protect minors, especially from being drawn into these fraudulent, potentially predatory relationships through fake marriages.
That makes sense. It's a strong protective measure built right in.
Okay, so from protecting the legal contract of marriage, we now shift gears a bit. We're moving to protecting what you might call the contract of kinship relationships that are forbidden because of blood ties or adoption. This is section 25.02, Prohibited Sexual Conduct, commonly known as incest.
Right. So this section draws clear lines based on family connections.
Yeah.
What specific relationships does the law say are off limits for sexual activity, regardless of whether the original relationship was, legitimate or not?
The statute lists them out pretty comprehensively in subsection A, and it covers two types of acts. Either sexual intercourse or what the law calls deviate sexual intercourse. The key is that the person has to know the relationship falls into one of these forbidden categories.
Okay, so what's on the list?
All right, first, it's the direct line, an ancestor or descendant. That's parent, grandparent, child, grandchild, and so on. Doesn't matter if it's whole blood, half blood, or through adoption.
Okay, direct line. What else?
Second, step relationships. A current or former stepchild or step-parent. Third, moving sideways a bit.
Right.
A parent's brother or sister. So your aunt or uncle, again, whole or half blood.
Right. And siblings.
Definitely. Fourth is a brother or sister, whether they're whole blood, half blood, or adopted siblings.
So the law treats adopted siblings exactly the same as biological ones here.
Interesting. What about the next generation out, like nieces, nephews, cousins?
They're included too. Fifth is the child of a brother or sister, so nieces and nephews. And sixth, the child of an aunt or uncle. That means your first cousins.
First cousins too. Wow.
Yes, the prohibition extends all the way to first cousins. It's a very broad definition trying to maintain clear boundaries within close family structures. Okay, we need to be precise about the acts themselves. Sexual intercourse seems straightforward, but deviate sexual intercourse often has a specific legal meaning. What does the code say here in subsection B?
Good point. Clarity is essential. So sexual intercourse is defined simply as any penetration of the female sex organ by the male sex organ. Pretty standard.
Right.
Deviate sexual intercourse is defined as any contact between the genitals of one person and the mouth or anus of another person. But, and this is key, it has to be done with the intent to arouse or gratify the sexual desire of any person. That intent element is crucial for this definition.
Got it. Intent is key for deviate sexual intercourse. And like bigamy, the penalties here seem to depend on how close the relationship is.
That's right, subsection C. The standard offense under this section for most of those relationships we listed is a felony of the third degree.
Okay.
However, if the offense is committed with someone in that direct line, an ancestor or descendant, covered back and sick, the penalty is elevated, it becomes a felony of the second degree.
So violating that immediate direct lineage carries a higher penalty.
Exactly. The law views that as a more egregious violation of the family structure.
You know, thinking about these first two sections together, bigamy and incest, is fascinating. The law is essentially setting up boundaries around two different kinds of fundamental contracts, isn't it? The legal contract of marriage and the sort of natural contract of kinship.
That's a great way to put it. And violating either carries significant felony penalties, which really underscores how seriously the state takes protecting the basic structure of the family unit, however it defines it.
All right, let's move into part two. We're shifting from these general family relationships to a really critical and often very emotional area: minor children and custody.
Yes, this is where civil disputes can quickly escalate into criminal matters.
Exactly. When someone, usually a parent, violates a court order about a child under 18, that's when Section 25.03, interference with child custody, comes into play.
Right. And the statute really spells out the serious criminal consequences of defying court authority over a child. Subsection A lays out 3 distinct ways a person can commit this offense by basically unlawfully taking or keeping a child.
Okay, what's the first way?
The first one is maybe the most straightforward: violating an express court order. This happens when someone takes or keeps a child knowing that their action goes directly against the specific terms of a judgment or court order dealing with custody or possession. And that includes temporary orders, which are really common early in divorce or custody cases.
Knowledge is key there. They have to know they're violating the order.
Yes, knowledge is an element. The second way this offense happens deals with interfering while a case is still being decided by the court.
Preventing the court from doing its job, essentially.
Pretty much. The second violation occurs when someone who hasn't been awarded custody knows there's a lawsuit affecting the parent-child relationship going on. Could be a divorce, a custody modification, a habeas corpus case, anything like that. And they take the child outside the court's defined geographical jurisdiction.
Which is usually what? The county or district?
The statute specifies the judicial district, or if there isn't one specified, then the county where the suit is pending. And crucially, they have to do this with the specific intent to deprive the court of its authority over the child.
So, classic example. Mom knows the custody hearing is next Tuesday, so on Monday she packs up the kid and drives across state lines, planning not to come back.
Yeah.
That's this offense.
That's exactly the kind of scenario this targets. And then there's a third violation, which is even more extreme: international abduction.
Taking the child out of the country.
Right. Taking the child outside the United States with the intent to deprive someone else who has lawful rights of possession or access, and doing it without that person's permission. That's obviously a very serious escalation.
Definitely. Now, there's also a subsection B that deals with something a bit different, right? Not taking, but maybe influencing the child.
Yes, that's non-custodial enticement. This is a separate offense aimed at a non-custodial parent, someone who doesn't have primary custody. They commit this if they knowingly entice or persuade the child to leave the lawful custody of the parent or guardian who does have custody, and they do it with the intent to interfere with that lawful custody.
So maybe encouraging the child to run away from the custodial parent's home.
That kind of thing, yes. It addresses that more subtle disruption.
Okay, these rules seem pretty strict. But what about emergencies? Or genuine mistakes?
Yeah.
Does the law allow for any defenses here?
It does. The legislature built in some really important safety valves or defenses. First, for that offense of taking the child outside the geographical area while a suit is pending, violation number 2 we discussed, subsection A, there's a specific defense.
Okay.
It's a defense if the person voluntarily returns the child to that geographic area within 3 days of taking them out.
Ah, so a very short window to undo a bad decision.
A very short, specific window. It recognizes that maybe someone panicked, but gives them a chance to quickly correct it without facing criminal charges for that specific violation.
That seems practical. What about the international cases? Those must have defenses too, given how complicated they can get.
They do under subsection C1. There are 2 specific affirmative defenses for retaining a child overseas in violation of a 3. Remember, with an affirmative defense, the person charged has the burden to prove it applies.
Right.
The first defense is straightforward. If the person kept the child overseas based on a valid court order from a U.S. or another country's court that allowed them that possession or access. The second is more about circumstances.
Like things beyond their control.
Exactly. It's a defense if the retention happened only because of circumstances beyond the person's control. Think natural disasters, civil unrest, maybe a sudden medical emergency, provided they promptly notified the other parent or person entitled to possession, or at least made reasonable attempts to do so.
Okay, and isn't there a really critical exception related to family violence?
Yes, absolutely vital. Subsection C2 provides the family violence exception. That whole international abduction rule in the 3 simply does not apply if the person who took or kept the child overseas actually was entitled to have possession at that time, and they were fleeing because family violence had been committed or was about to be committed against them or the child.
That is powerful. It ensures the law doesn't become a tool to trap someone or a child in an abusive situation just because of borders.
Precisely. Safety has to come first in those situations.
Now, penalties.
Yeah.
Both this interference with custody, 25.03, and a related offense, abduction for remuneration, 25.031, are classified as state jail felonies. Can you remind us what that means?
Sure. A state jail felony is the lowest level of felony in Texas.
Okay.
The punishment range is typically between 180 days and 2 years in a state jail facility, plus a possible fine. It's less severe than other felonies, but it is still a felony conviction with all the consequences that carries.
Right. And that other section, 25.031, abduction for remuneration, that targets something specific.
Yes. It targets the hired gun scenario. Someone commits this offense if they take money, or are promised money, to abduct a child using force, threats, hiding, lying, whatever, knowing that child is subject to a court order regarding their care or custody. It's a state jail felony, too, singled out because the payment aspect shows a different kind of criminal intent, maybe more organized.
Okay, so that covers direct interference with custody orders. Now let's broaden out a bit to other actions that interfere with a parent's or guardian's general authority over a child. First up is enticing a child, section 25.04.
Right. This is somewhat similar to that non-custodial enticement we mentioned, but it applies more broadly to anyone, not just a parent. It's knowingly enticing, persuading, or taking a child who is younger than 18 away from their parent, guardian, or whoever has lawful charge with the specific intent to interfere with that lawful custody.
And the penalty here can vary wildly depending on why the person enticed the child, right?
Hugely different. Normally, enticing a child is a Class B misdemeanor, which is serious but not a felony. However, if the prosecution can prove that the person enticed the child with the intent to commit another felony against that child, things like sexual assault, aggravated kidnapping, trafficking, then the enticing offense itself jumps all the way up to a felony of the 3rd degree.
Wow. So the underlying criminal intent against the child is the game changer there.
Absolutely. It turns a misdemeanor interference into a serious felony.
Okay, next up we have the financial side of things. Criminal Nonsupport, section 25.05. This seems pretty straightforward, failing to pay child support when you're supposed to.
That's the core of it, yes. An individual commits this offense if they intentionally or knowingly fail to provide support for their child who is younger than 18. It also applies to any child subject to a court order requiring support, even if they're over 18, like for college support sometimes.
Does it matter if the parents were married?
No. Subsection B makes it clear. Child includes a child born out of wedlock as long as paternity has been legally established, either the person acknowledged paternity or a court determined it in a civil case.
Now, the most common excuse or reason people give for not paying support is that they just can't afford it. Does the criminal law recognize that as a defense?
It does. Subsection D provides an affirmative defense. It's a defense to prosecution if the person can prove they could not provide the support. Again, being an affirmative defense, the burden is on the defendant to show this inability was real, not just an unwillingness to pay.
And it's important to note, right, that a criminal case for non-support doesn't stop the civil courts from still trying to collect the money.
Exactly. The civil enforcement process continues regardless of any criminal charges. The penalty for criminal non-support is a state jail felony.
Okay, one more in this part. Harboring a runaway child, section 25.06. This isn't about taking a child, but about providing shelter when you shouldn't.
Right. A person commits this offense if they knowingly harbor a child, meaning they provide shelter. And crucially, they have to be criminally negligent about whether the child fits 2 criteria. 1, the child is younger than 18, and 2, the child is either an escapee from detention, police custody, etc., or they've voluntarily left home without permission for a substantial amount of time.
Okay, criminally negligent. What does that mean here?
It means the person should have known, given the situation, that the child was likely a runaway or escapee, but they unreasonably failed to recognize that risk. It's a lower standard than knowingly, but more than just simple carelessness.
Are there exceptions for, say, relatives, or if someone calls the authorities?
Yes, there are two main defenses. First, in subsection B, it's a defense if the person harboring the child is related within the second degree by consanguinity, blood like an aunt or grandparent, or affinity, marriage like a step-parent. Second, under C, it's a defense if the person notified the authorities, law enforcement, or the agency the child was missing from, or the parent guardian within 24 hours after finding out the child was an escapee or voluntarily absent. That encourages people to report.
And there's also a specific duty placed on law enforcement connected to this, isn't there? Something about a national database.
Yes. Subsection E. It mandates that when law enforcement gets a report about a child who is missing or has escaped custody, they must immediately enter a record about that child into the National Crime Information Center, the NCIC database.
So that ensures missing kids get flagged nationwide right away.
Exactly. It's a critical step for recovery efforts.
Okay, let's move into part 3. This is where, as you said earlier, things get really interesting, especially with recent legal changes. We're talking about violations of court orders specifically designed to protect people, usually in family violence situations. Section 25.07, violation of certain court orders.
Yeah, this section is huge. It's really the main tool the criminal law uses to enforce protective orders and bond conditions related to family violence, stalking, sexual assault, even child abuse cases. It's about making sure those orders have teeth.
And the scope of what kind of orders this applies to is pretty broad, right? It's not just final protective orders.
Not at all. It covers conditions set on bail after an arrest for family violence or related offenses. It covers emergency protective orders issued by magistrates. It covers temporary and final protective orders under the Family Code chapters dealing with family violence, Chapter 85, sexual assault or abuse, stalking, trafficking, Chapter 83. And it even covers orders from Child Protective Services cases, Chapter 261. It's very comprehensive.
Okay, so when one of those orders is in place, what specific actions does subsection A say are illegal? This listlet's long and detailed.
It is, and it's been updated significantly over the years to cover more types of abuse. Let's break it down. First, the obvious one. Committing family violence itself, or related acts like assault, sexual assault, stalking, trafficking. Violating the order by doing the thing the order was meant to stop.
Makes sense. What else?
Second, threatening or harassing communication. This is broad. It includes communicating directly in a threatening or harassing way, communicating a threat through someone else, or even any communication at all in any manner if the order specifically prohibits all contact except maybe through lawyers.
Okay, third involves location, right? Going places.
Yes, going to or near protected locations. That typically includes the residence or place of employment of the protected person. It can also include child care facilities or schools regularly attended by a child protected by the order, keeping physical distance.
Fourth is about weapons.
Right, simply possessing a firearm. If a protective order prohibits firearm possession, just having one is a violation of this section.
Now let's focus on some of the newer additions. These seem to reflect a growing understanding of different forms of abuse, including non-physical ones and technological ones.
Absolutely. These are really important updates. Fifth on the list is harming, threatening, or interfering with a pet, companion animal, or assistance animal that belongs to or is kept by the protected person. Abusers often use pets to control or coerce victims, so the law now explicitly protects those animals within the order.
That's a big one. What's sixth?
Sixth deals with tracking technology imposed by the court, tampering with or removing a global positioning monitoring system, GPS. If the defendant is ordered to wear an ankle monitor, for example, messing with it is its own violation under this section.
And seventh seems incredibly relevant today. Digital tracking and monitoring.
Yes, this is huge. The seventh prohibited act is tracking or monitoring the personal property or motor vehicle of the protected individual without their consent. And the law is specific here. It includes using tracking applications on phones or other devices, attaching a dedicated tracking device like an AirTag, or physically following the person, or even arranging for someone else to follow them.
So cyber stalking and using tracking tech is explicitly a violation of the protective order now.
Explicitly, it's a direct legislative response to how technology is used in abuse.
Now, the law also includes a couple of really important clarifications in subsections D and E about how these orders are enforced. Why are these needed?
They're crucial safeguards against common ways these orders can be undermined or misused. Subsection D states very clearly that if the protected person takes some action towards reconciliation or even invites the defendant over, it does not affect the validity of the order or the duty of a police officer to enforce it.
Why is that so important?
Because victims are often pressured, manipulated, or threatened into seeming to reconcile or drop the order. This rule says it doesn't matter what the victim says or does. The order is valid until a judge changes it. Police must enforce the written order, period.
That protects victims from coercion. What about subsection E?
Subsection E protects the victim in a different way. It says a police officer may not arrest the person who is protected by the order for violating that same order.
To prevent the abuser from setting the victim up.
Exactly. Prevent scenarios where the abuser trips the victim into technically violating a term, like contacting them, and then calls the police to have the victim arrested. The focus stays on the person restrained by the order.
Okay, let's get into the penalties for violating these orders. Section 25.07. They escalate pretty quickly. What's the starting point?
The standard baseline offense for violating one of these conditions is a Class A misdemeanor. That's the highest level misdemeanor, punishable by up to a year in county jail and/or a fine.
But it can become a felony, right? When does it jump to a state jail felony?
It bumps up to a state jail felony under two conditions. First, if the order being violated was issued after the person had already been convicted of an offense involving family violence, basically, a violation while on probation or parole for a prior domestic violence crime.
Okay.
Or second, it's a state jail felony if the person violates certain specific conditions like the communication, proximity, pet interference, or tracking rules while possessing a deadly weapon at the same time.
So weapon possession, doing those types of violations, triggers the felony charge.
Correct. And then it can go even higher.
Do a third-degree felony. What triggers that?
It becomes a third-degree felony punishable by 2 to 10 years in prison in two main scenarios. First, if the person has 2 or more previous convictions for violating protective orders, under this section or the next one we'll discuss, 25.072, this targets repeat offenders very harshly. Or second, it's a third-degree felony if the way they violated the order was by committing an assault that causes bodily injury or by committing the offense of stalking. So if the violation itself involves physical violence or stalking behavior, it's automatically elevated.
This really highlights the law's focus on patterns of behavior and prior history, doesn't it? Which leads us perfectly into the next sections, which are specifically about continuous or repeated offenses.
Exactly. The law explicitly recognizes that domestic violence and violations of orders are often not isolated incidents, but patterns of conduct. These next two statutes are designed to prosecute that pattern.
First is Section 25.072, repeated violation of certain court orders.
Right. This creates a distinct offense. A person commits this crime if, within a single 12-month period, they engage in conduct that violates Section 25.07, the section we just discussed, 2 or more times.
So it's not just one violation, but a pattern of violations within a year.
Precisely. It criminalizes the pattern of repeatedly breaching those protective boundaries set by the court.
Is there anything special about how a jury considers this?
Yes. Subsection B clarifies the jury's role. If it goes to a jury trial, the jury doesn't have to agree on which specific acts constituted the violations, only that the defendant did, in fact, commit the underlying 25.07 violation 2 or more times within that 12-month window. They have to be unanimous on the number of violations within the time frame.
Okay. And the penalty?
It starts as a felony of the 3rd degree, but similar to the escalation in 25.07, it bumps up to a 2nd-degree felony if at least one of those underlying violations already qualified as a state jail felony under 25.07, meaning it involved a weapon or violated a post-conviction order.
So again, harsher penalties for repeated, more serious violations. This seems like a strong tool against people who just won't stop.
It is, and running parallel to that, there's Section 25.11, continuous violence against the family. This one focuses specifically on repeated physical assault.
Okay, how does this one work?
It's another pattern crime. A person commits this offense if, again, within a 12-month period, they commit assault causing bodily injury. That's the specific type, Section 22.01A1 assault, 2 or more times.
Against whom?
Against a person or persons whose relationship to the defendant is defined under the Family Code's definitions of family or household member or someone they're in a dating relationship with. It targets repeated domestic assaults.
And the jury requirement here is even more flexible, isn't it? It seems designed to overcome common difficulties in prosecuting domestic violence cases where victims might not remember exact dates.
That's the absolute key insight here, yes. Subsection B is critical. The jury does not have to agree unanimously on the specific conduct that constituted each assault. They don't have to agree on the exact date or even the specific location or county where each assault happened.
Wow.
All they have to agree on unanimously is that the defendant committed that type of assault against a family or household member 2 or more times during that 12-month period.
So the focus is entirely on proving the pattern of abuse, not getting bogged down in the details of each separate incident, which can be hard to recall under trauma.
Exactly. The legal structure here deliberately targets the continuity of the violence itself as the crime. It makes it more feasible to prosecute sustained abuse. The penalty for this offense is a felony of the 3rd degree.
That's a powerful statement. The pattern is the crime, even if the individual pieces are hard to pin down perfectly.
A very important legal adaptation for these kinds of cases.
Okay, let's shift into our final section, Part 4. Here we're looking at offenses related to how children are transferred, especially around adoption, and also guardianship rights.
Right. The main theme here is the state regulating the transfer of children very carefully to prevent them from being treated like commodities, essentially, protecting children from being bought, sold, or improperly transferred.
Makes sense. We start with Section 25.08, Sale or Purchase of a Child. The title says it all, really.
Pretty much. It's designed to stop money from changing hands directly for a child in the context of adoption. A person commits this offense in one of 2 ways. Either they offer or give something of value to get possession of a child under 18 for adoption, or they solicit or accept something of value for delivering or letting someone else have possession of a child for adoption.
Thing of value seems broad. Could that accidentally criminalize legitimate adoption expenses, like lawyer fees or medical costs for the birth mother?
That's a crucial question, and the law anticipates it. Subsection B provides very specific necessary exceptions. It clarifies that thing of value does not include several legitimate payments,
Such as
fees paid to a licensed child-placing agency for their services, fees paid to professionals like lawyers, doctors, mental health counselors for their usual services related to the adoption, reimbursement of actual legal or medical expenses that were incurred for the child's benefit, and reimbursement of necessary pregnancy-related expenses paid by a licensed agency for the birth mother's benefit.
So paying for professional services or covering real costs associated with the pregnancy and the child's care through proper channels. That's okay, but paying someone directly for the child is not.
Exactly. Payment for regulated professional services or documented expenses is fine. Payment just to hand over the child is a 3rd-degree felony.
And does the penalty increase if there's a connection to trafficking?
Yes. Reflecting the serious concern about trafficking, if the person commits the sale or purchase offense with the intent to also commit offenses like human trafficking or certain sex offenses involving children, the penalty jumps up to a 2nd-degree felony.
Okay. Related to this is Section 25.09, Advertising for Placement of a Child. This seems aimed at stopping unlicensed people from trying to arrange adoptions publicly.
That's right. It prohibits advertising in public media, and the law explicitly includes the internet and other public computer networks that you will place, provide, or obtain a child for adoption or for permanent physical custody. Basically, no public soliciting for private adoptions.
Is there an exception for legitimate adoption agencies?
Yes. Subsection B says this doesn't apply to licensed child-placing agencies as long as they identify themselves as such in the advertisement. They're regulated, private individuals are not.
What's the penalty for illegal advertising?
It starts as a Class A misdemeanor. However, if the person has been convicted of this same offense before, a repeat offense escalates significantly to a 3rd-degree felony.
So the state really wants to keep adoption arrangements within the regulated system.
Very much so. Now, the next section, 25.081, deals with something that's gotten more attention recently, often called rehoming. It's unregulated custody transfer of an adopted child. This targets what happens after an adoption is final, if the adoptive parents try to give the child away without court oversight.
Right. This seems designed to prevent adopted children from being passed around outside the legal system.
Exactly. The offense is committed when a parent or legal conservator transfers permanent physical custody of their adopted child, who is under 18, to someone else without getting the required court approval as mandated by the Family Code. It's also illegal to help make that happen, recruiting people, harboring the child, transporting them for that purpose.
That sounds very strict.
Yeah.
what if an adoptive parent needs a relative to care for the child long-term because of, say, a serious illness or military deployment? Is that a felony?
No, thankfully the law has common sense exceptions for those situations listed in subsection D. This offense does not apply to placing the child with a licensed agency, with DFPS, the State Child Welfare Agency, with an adult relative, a step-parent, or another adult who has a significant, long-standing relationship with the child.
Right.
It also exempts temporary placements needed for things like vacations, parental illness, military service, incarceration, or incapacity. And placements through formal processes like the Interstate Compact on the Placement of Children are also exempt.
So it's really targeting those permanent, unregulated handoff to strangers or distant acquaintances, not necessary family care arrangements.
Precisely. It's trying to prevent children from falling through the cracks after adoption. The base penalty is a third-degree felony.
And does it escalate like the sale offense if trafficking is involved?
Yes. If the unregulated transfer was done with the intent to commit trafficking or related sex offenses, it becomes a second-degree felony.
Okay, finally in this chapter, we have section 25.0, interference with rights of guardian of the person. This extends similar protections beyond parents to court-appointed guardians.
Right. When a court appoints a guardian for someone, often an incapacitated adult or sometimes a minor, that guardian has what's called a possessory right. The law defines this as the right to have physical possession of the ward, the person under guardianship, and to establish their legal home.
So this offense is basically interfering with that right.
Exactly. A person commits the offense if they take, keep, or hide the ward, knowing that doing so interferes with the guardian's legal possessory right. The penalty is a state jail felony.
Is there an exception for, say, adult protective services intervening?
Yes. Subsection D clarifies it doesn't apply to government agencies that are legally authorized to take or retain the ward under other specific laws, like protective services statutes in the Family Code or Human Resources Code. It ensures official protective actions aren't criminalized.
Okay, that covers the whole chapter. Quite a journey through the legal definitions of family and the consequences for violating them.
It really is. And if you take a step back and look at Chapter 25 as a whole, you see a very clear picture emerging. The law is intensely focused on drawing lines and imposing criminal penalties for major disruptions to legally recognized family structures, whether that structure is marriage, blood ties, a court custody order, a protective order, or even a guardianship.
Yeah, we covered a lot. We started with the integrity of marriage in the bigamy section, then the fundamental kinship boundaries with incest. We moved into the critical area of child custody, interference, enticement, non-support, harboring runaways, and then into the really significant area of protective orders, where we saw how the law is adapting to things like digital tracking and prosecuting patterns of abuse with those continuous offense statutes. And finally, the strict rules around adoption and guardianship transfers.
So thinking about what this all means for you, our listeners, I think the biggest takeaway is just how complex and highly codified these relationships become once the legal system gets involved, especially concerning children or safety orders. These aren't just private family matters anymore in the eyes of the criminal law. Violating these rules, these court orders, these established processes, it can lead to felony charges. It demands really rigorous adherence to the legal framework.
And like we saw with those updates to Section 25.07 for protective orders, adding protections against pet abuse, GPS tampering, digital monitoring, the trend seems clear. The law is moving towards stronger protections for victims, especially in domestic violence contexts, and harsher consequences for repeat offenders through sections like 25.072 and 25.1.
Which does raise a really interesting question for the future, doesn't it? We've seen the law adapt to things like GPS trackers and tracking apps, but technology keeps accelerating. What about harassment using AI, or deepfake videos used against a family member, or other surveillance tech we haven't even thought of yet? How will Chapter 25 or laws like it continue to evolve to shield people from these emerging forms of abuse and control within families?
That is definitely something to think about long after we wrap up here. A challenging question for lawmakers and for all of us, really. Thank you so much for joining us on this deep dive into the legal boundaries of the family under the Penal Code. We really hope breaking down this complex chapter has given you a clearer, more critical understanding of these vital legal structures.
Thanks for listening.
Until next time, keep exploring what matters.